right, if we're ready, I'm going to go ahead and let everybody in.
Good evening. Thank you for joining us tonight. Thank you again for joining us tonight and welcome. I'm Kristen, Director of Alumni Relations for the College of Law. Thank you for joining us for tonight's program, Antitrust and Competition Law. I've had the pleasure of helping plan tonight's program along with the College of Law's Assistant Dean for Advancement, Sophie Dejanay, Corporate Law Society President 3L, Connor Bowers, and Corporate Law Society Vice President 2L, Kelsey Gonzalez. Before we start our program, I wanted to share a few housekeeping pointers to maximize our time together. We are in meeting mode, which means we can all see and hear each other. When you're not speaking, let's turn our audio off so that we avoid noise interference. But please keep your camera turned on. We want to see all of you. During the discussion, please turn on speaker view. For anyone that requires captioning, please click on the live transcript icon along the bottom toolbar, then click on Show Subtitle. Please know that we are recording our session. Now to get us started, I'd like to introduce Corporate Law Society Vice President 2L, Kelsey Gonzalez. Kelsey?
Hi, everyone. Thanks, Kristen. I am Kelsey Gonzalez, as previously mentioned. I just want to thank you guys for taking the time to join us today. And thank you to all of our panelists. And of course, the Office of Alumni Relations. We really couldn't put these panels on without you guys, as usual. So since we have a smaller number of people, if we could just briefly go around and just introduce ourselves, maybe what class you're in, what year, and then where you might be tuning in from, just so we can get a little better acquainted. And I will go ahead and start. Again, my name is Kelsey. I'm a 2L. And I'm currently in Syracuse. So Connor, we'll hop over to you. You're actually next on my screen.
I'm Connor. I'm a 3L, and I'm from Bloomfield Hills, Michigan.
Okay, and then I see Alyssa.
Hello, I'm a 2L, and I'm in Syracuse right now.
Hey, Liv, I see you next.
Good afternoon, everyone. I'm Olivia Stevens, and I am a 2L, and I'm about an hour away from the city of Newburgh, New York.
And then we have Alexandre. I'm sorry if I mispronounced your name.
Oh, I'm a previous student of the LLM program of Syracuse University. At the moment, I am in Iowa.
Awesome, awesome. And I think that's everyone. All right, so with that, I would just like to introduce our moderator, Professor Ghosh.
Thank you, Kelsey, and thank you, Kristen and Sophie and Robert, everybody who makes this possible, Kyle. Connor, I've not had you or met you before, but it's great to meet you, and I'm really looking forward to talking with our alumni today about these very interesting issues in antitrust. Kelsey, I have talked with you about antitrust occasionally in the last couple of months, and I'm not going to bother you about your note, but it's what I've read. It's really exciting, and maybe we can talk about that as well. But let's turn to our alumni panelists. Welcome, Jim. Welcome, Yvette. Welcome, David. I think everybody knows everybody, but just brief introductions, and then we can launch into our discussion. James Southwick, I believe class of '89, is currently with Susman and Godfrey in Houston, Texas. Yvette Tarlov, I think class of '86, correct me if I got this wrong, currently with the Antitrust Division at the Department of Justice in Washington, D.C. And David Wales, blanking on your class of '89 as well, or?
95, believe it or not.
95, sorry,
Yeah.
okay.
That's okay.
We graduated right around the same time, actually a few years younger than me, so welcome. And you're currently with Skadden Arps in Washington, D.C. And what brings them together, what they all have in common, other than Syracuse, is the love and passion for antitrust law. And before we delve into that passion, let's make sure we all understand what antitrust law is. So Yvette, would you like to get us started in giving us a 2-second summary of what antitrust law is, and then we'll talk more in detail about it.
Sure. Wow. Well, first, thank you all for putting this panel together and for inviting me to be on it. I do have to disclaim that the views I'm expressing tonight are my personal views and not official positions of the United States Department of Justice. So in case I get the definition of antitrust law wrong, you can blame me and not the division. I guess antitrust law to me, I mean, I thought, it's really one of the most intellectually rigorous, I think, areas of the law. It combines law with economic theory. And, you don't need to be an econ major to be an antitrust lawyer, but I do think you can't be scared of numbers. And you really need to have very sharp analytical skills. In terms of what I do, when people ask me that are not antitrust lawyers, I like to say that, my job is to try to ensure that markets are working competitively. So that's how I define it.
And you represent the government side. James, have you been on both sides of the V? Or have you been more of a plaintiff's or defendant's side? Or?
I've certainly been both plaintiff's counsel and defense counsel, and kind of ebbs and flows. I started out in New York with a defense firm, and then I moved to Houston, and my current firm is largely a plaintiff's firm, at least as it comes to antitrust. But actually these days, I actually have a very active cartel case up in Western District of New York where I'm on the defense side. So both sides of it.
What was your 2-second, I've never heard of antitrust law, tell me what it is, answer me?
It's the law of competition between, in business, what's fair and what's unfair. What can you do? What can't you do? And one of the things I like about antitrust law is the line is so blurry between what's fair and what's not fair. In the world of torts or something like that, look, if I come and I bonk the professor, over the head, with a book or a bat, everybody knows that's wrong, okay? But in the world of competition between businesses, what some people consider, absolutely perfectly fair and ought to be legal behaviors, others consider just terrible. So there's a lot of room in antitrust law for argument amongst lawyers, and often, as Yvette said, with the assistance of economists, as to what you can do and what you can't do in the world of competition between businesses.
David, would you've been on both sides of the V as well, or?
If you look at my resume, I'm kind of the guy that can't hold a job for more than a few years, but I've had the pleasure of actually working on both sides, and spent most of my career on the defense side, working at law firms and representing corporations as they deal with antitrust, both from a governmental prosecution perspective, but also private. There's so many multi-facets. I agree with what Jim and Yvette just said. Antitrust has so many different facets that you can become an antitrust lawyer, even though you might want to be more a plaintiff or a defendant. You want to be in the government, you want to be in private practice. You want to do, conduct matters, merger matters. And so I had the privilege of spending 2 tours in the government. So I worked actually at Yvette's employer, Department of Justice, for a couple of years doing antitrust prosecution, and then also spent 3 years at the Federal Trade Commission, which is the other federal enforcer. And I guess what I would say, to your question about what is antitrust, it really is protecting competition. I think Yvette and Jim gave great answers. And it just has so many different facets to it. But what I love about it is just the vagueness of it, and Jim touched upon this as well. If you look at the antitrust statute, like Section 7 of the Clayton Act, which says that, if basically mergers that substantially lessen competition are unlawful. What does that mean? Nobody knows what that means, and so there's a whole rich case, a whole set of common law that goes into that, and courts that have to grapple with that, but also economics that go into that. Yvette at DOJ and the FTC issue guidelines too. And so I like it because it's a real challenge to figure out what the right answer is, and it is very vigorous and rigorous. But also too, something that I find a lot of fun in having to help clients navigate that, because they want to, get their merger done, or, want to defend, potential monopolization case by DOJ. And they really just want results. And so you really have to be able to explain a very complex area of the law in a very simplistic way, which I enjoy.
Great. And how did you get into it? I mean, is there something so vague as you describe it? How would you ever prepare for that in law school?
It's funny. I was a summer associate at a law firm and got to rotate through kind of randomly antitrust and just fell in love with it, for a lot of the reasons we talked. I actually took antitrust at Syracuse and I hated it. I didn't really like the topic, and it was really, focused more on the non-merger part. But what I was able to do was get exposed to it in kind of a law firm setting and really just enjoyed the vagueness of the law. But also too, one thing that I really like about it as well, at least on the defense side, and I think also maybe on the prosecution side, is you really get to spend time with the business people. It's not the lawyers of the client, it really is the business people, because you have to understand the market, the products, and I find that to be really a lot of fun. So you get to spend a lot of time with the business people, and it's always different. You're learning one day about toilet paper, the next day you're learning about trash, the next day you're learning about pharmaceuticals. It's just a really neat way to get exposed to the business side as well.
Was that your story as well? Have you went in the government side? I mean, do you think it's as vague as they describe it? I'm sure the private sector people like to make it vague.
Well, they do. I mean, no, I think it's fair. We try to issue guidelines, and but there is no real bright line. And in fact, I think a lot of what we do is, trying to put the pieces of a puzzle together when we're building, or trying to investigate whether something is a violation of the antitrust laws, or if we think it is, prosecuting that violation. And, the puzzle pieces are all kind of gray. And so, but when you find that one piece that actually kind of puts that puzzle into focus, and you can see that big picture, that is really cool. That's why we do what we do. I mean, I'm learning every day, as David and Jim both alluded. I mean, I learn about all sorts of different industries. You talk to all sorts of different people, and I fell into antitrust. I actually took antitrust at Syracuse, and I liked it. And that was just sort of like, a light going on for me. I was a molecular biology major undergrad. Going to law school was probably one of the most irresponsible things I'd done to that date. But I really, I just really fell in love with antitrust in law school. It was just very logical. There was analysis, so.
Did you go a straight path from there to the government? Did you go through like the DOJ?
I did not. I actually did work in a law firm. I worked at Howry and Simon, which is no longer. For several years. So I went from private practice to the government, and I've been in the government for over 25 years. So
Howry
had a personality.
Howry had a very notable antitrust practice back in the 80s and 90s, really cranking through the economic models as well as the legal analysis, from what I remember.
Yes.
Jim, what was your story? Was it your least favorite class in law school, or is it a class you avoided? Or
I didn't even take antitrust in law school, and I think it wasn't even offered, because the guy who had been, what I've learned since I graduated was that the guy who used to teach it during the years that I was there was actually doing a stint as the U.S. attorney for Northern District of New York at the time. I don't think there was even something I could take, but I was an undergraduate economics major, and took a course called Industrial Organization, where what we did was we read antitrust case law as an undergraduate, and certainly was the most interesting class I took at the time. And when I was in law school and looking for a job, I specifically looked for firms that had notable antitrust practices as places I wanted to work.
I see. And how about, the thing that's interesting about antitrust and maybe corporate law practice is it's geographically diverse. Did you focus in Texas, or did you look all over? Or
Now, I'm a native of Syracuse, and that's why I ended up in law school there. But I started my career in Manhattan, and the Texas thing just happened due to ended up having a long trial in Houston, and ended up marrying my co-counsel. So
It's, so I didn't mean to get into the first, but it's good. I'll be another podcast sometime.
Right.
How about you, David? I mean, did you look broadly, and did you look at antitrust or?
Yeah, I mean, it's in terms of kind of subject areas. I mean, I think when I was a summer, I went to Syracuse. I knew I wanted to practice in New York, New York City, and so I got a summer associate job there, not really knowing what I wanted to do. I think I picked, M&A #1, litigation #2, because that, you're a lawyer, pick that, and I think I picked antitrust like 4th because the Microsoft case was kicking around. And I got antitrust and bankruptcy, and bankruptcy was like, no offense to any bankruptcy lawyers, but I thought that was the worst. But I got to go in the antitrust practice, and got to see what they did. Loved the interaction with the clients. I started in New York, so I started at a big firm in New York. Really enjoyed it, but had the benefit of working with some lawyers of the firm who had worked with the government and spoke highly of it. Knew at some point I probably wanted to leave New York. So I moved to Washington, D.C. and transferred to my firm's D.C. office after about a year and a half in New York, and have been here for, 22 years, And I think, for me, for my practice, which, is really appearing before, DOJ and the Federal Trade Commission, for the most part, it's a great, place because you're there at the heart of the beast, and get to meet the people. And part of the really cool part of antitrust as well, in addition to the law, is just the different types of practices. And so I'm not a litigator. I don't want to be a litigator. I'm more an agency person, interacting with the agencies. But if you want to be a litigator, you can be an antitrust lawyer. If you want to, do more counseling, you can be an antitrust lawyer. So there's lots of different, opportunities to try out different ways of practicing the law.
And Yvette, when you were in private practice, were you focusing largely on litigation, and that was what, as I understand, Harry was known for, or did you do a mix of?
Yeah, no, I was mostly focused on litigation. I actually started at a small antitrust firm in Seattle, which is where I'm from.
I see.
I spent about a year there, but I wasn't getting a lot of antitrust work. So then I moved to DC to be closer to the agencies. Although I spent most of my career at Howry, I didn't do any agency work. I didn't do mergers. I did mostly plaintiffs work. So. Yeah.
So you went
and
from
here I do, we have a mix. So
you went from Seattle to do antitrust in DC right when the Microsoft case was starting. Though I don't know if you're involved in that. The biggest antitrust case in the last couple of decades, starting in Seattle. So was a lot of your coursework in law school? Was it a mix of litigation and corporate, or how did that play in, or
yeah, at the time, and I just may be misremembering this. I think that at the time I was in law school, we were sort of encouraged to focus in a general area. And the areas as I remember them were, international, environment. I mean, there were various paths you could go, and one was government and regulation. I just chose that because I really, I didn't want to be a criminal lawyer. I didn't think I wanted to be an international lawyer. And so I think antitrust and M&A were mergers and acquisitions were two classes that were in that kind of focus area. So that's how I didn't take a lot of litigation. I took evidence. I think I did moot court. I was on law review, but I didn't really focus on litigation in law school.
Which moot court did you do? Was it the one from the school, or did you do one of the competitions? Okay.
Yeah, no, it was the school, the court.
Jim, how about you? Were you heavy litigation in your coursework, or you did a mix, or?
I mean, I took a range of classes, but I always intended to be engaged in the litigation practice. That's just my unformed mind back then thought that's what lawyers did. So
yeah, and so you sort of you kind of did the standard litigate evidence and probably some trial practice. And what did you think prepared you well for where you are now?
I really think the classes that people derived the most were the procedure classes. I think civil procedure is really just absolutely critical to the effective functioning of our justice system, and it certainly plays an important role in, antitrust cases that I have, as well as every, non-antitrust cases. But I enjoyed the procedure, and it has proven to be absolutely critical to, like I say, the functioning of the court system.
Yeah. Yeah, no, you're certainly emphasizing that. I mean, did you do the BA and the corporate law classes as well? Did we offer courses in white collar crime and those types of things back then? I mean, that's certainly a part of the curriculum we're really focused on trying to expand and focus on now.
I mean, there was criminal procedure and constitutional criminal procedure and stuff, but I don't remember any sort of corporate law track. And we were talking about this before the students came on. I don't remember when I was in law school that there was any particular sort of concentration that you were asked to pursue.
Okay. Now, David, it sounds like your practice has been more transactional. Did you have more of a transactional focus in your coursework, or?
Yeah, I kind of took everything is the bottom line. I don't think I really knew what I wanted to do until I got a chance to go work, and my summer associate experience really kind of shaped what I thought I wanted to do. The one thing I will say, I did not, as I said, I did not love my antitrust class, but I took a law and economics class with Professor Malloy, who I think is still there, right? I liked that class because it was it was kind of like antitrust in the sense that you really thought about the law and how economics played together. And I found that to be really practical, helpful, and something that I really got a lot out of.
Yeah, no, that's great. One of the things I guess personally try to get across to students is not to narrow yourself, try to take a wide range of subjects, and it's your last chance to do that. But having said that, are there any regrets about classes you wish you had taken when you were in law school that maybe you would have changed helped your practice? Yvette, we can start with you.
It's been so long. I guess maybe taking some more trial ad courses.
Okay.
I really didn't see myself standing up in the courtroom. I was just kind of pushed that way by my law firm, and then so I think probably that. One course I think that is critical, and I do a lot of, in the hiring committee, and I do a lot of hiring, is legal writing.
Yeah.
So I think Syracuse, when I was there, and I hope you still do, have a strong legal writing and advocacy program, and that is probably to me the most important quality that you can bring, because you have to be able, the first thing that the court is going to see is your motion or is your brief. So you have to be able to.
Yep. Jim, any thoughts about what course you would regret not taking, or wish you'd taken, or even wish you'd offered? I should ask. I mean, things that could have been there.
I wish I'd paid more attention to my intellectual property class, because I took it my third year, second semester, and just kind of walked through it. But there's so much intellectual property issues, lawsuits, cases, that are facing, corporations as well as the courts these days. It's just all over everything. And it's often involving a very typical, posture for a case these days is one side's alleging, theft of trade secrets or improper misappropriation of some kind of trade secret. The other side saying, no, you're actually monopolizing this market. And, I've got a couple of cases sort of in that posture. So I wish I'd actually done more of that. And if you're at all interested in antitrust law, pay some attention to intellectual property classes as well.
Well, those are for reasons I'll talk about in my next question, near and dear to my heart. But you made that point. What mix in your litigation is private, and how much of it is government? Is most of it private, company suing company, rather than?
So my practice is all private litigation, but there is often, and I currently have this situation, also a government investigation or track, or one side's trying to get the government interested in, and I really feel ill at ease in that DC milieu of doing what David does or Yvette does, and I often will go to or team up with a DC lawyer if what we're trying to do is we've got a private lawsuit where we're alleging monopolization or some kind of unfair practice, and we want to get, the FTC or DOJ interested, we will often bring in a DC lawyer who has those connections, knows how those agencies work.
Yeah, I asked that in part because of you're mentioning intellectual property. How many of your antitrust cases start out as intellectual property cases with antitrust counterclaims, or I'm sure it's a mix of everything. Those are I do intellectual property primarily, and so that's at least my experience. Is that been yours as well, or?
That they start out as intellectual property cases?
Intellectual property cases.
Yeah, I think that's the standard, posture is the big companies sues first and claiming somebody's stealing their antitrust, stealing their secrets, and they get hit back with an antitrust claim saying, no, you're squashing competition.
I see. Interesting. Yeah, we'll get back to technology and IP in a minute, but David, I did want to pick your brain a little bit about courses you wish you had taken, and I've expanded the question a little bit to even courses that maybe you wish the school had offered, the College of Law had offered when you were there.
Yeah, I think, kind of goes to my mindset at the time, to be honest. I didn't really know what I wanted to do and didn't have a lot of direction. I went straight to law school from undergrad, which in hindsight, as I advise my kids as to what to do, I think probably would have been better if I had taken some time off to maybe get some more direction. But I ended up taking every kind of, a broader kind of set of classes like trust and estates and things I didn't think I ever would want to do. And I also thought, well, maybe I should take classes to be, make sure I can pass the bar, which that was not a smart thing. I thought, Barbary and the classes that we had back then, I was convinced if you're pretty smart, you could probably take one of those classes and pass the bar. They were that good. But, I really like my law and economics class. Like Jim too, I love the process. I love civil procedure. I actually took New York civil procedure only because I liked civil procedure, not because I thought I was going to practice and litigate in New York State. And I think, what I always tell people is you got to, do things that you really like, that give you good knowledge. But, at the end of the day, kind of, you never know where your career is going to take you. And so I don't know anybody, some people show up sometimes. I know I want to be an antitrust lawyer. I'm always a little suspicious when someone shows up, maybe about an undergrad knowing they want to be an antitrust lawyer, because I don't really know what it is. And so I think, my tip would be, if you like antitrust, obviously take as many classes as you can. I think some of that practical law, economic intersection makes a lot of sense. But the reality is, I don't know you really have to do that to be an antitrust lawyer. I certainly, didn't, and so I think everybody takes a different path. And I don't think there's any magic to it. And what I'd say real quick about economics, I do not have an economics background. I think I took it one class in college. And you can learn, what you need to learn. It's not rocket science. It really isn't. We hire, and Yvette knows this, we bring economists in. They have great economists at DOJ that she works with. They do the heavy lifting on the economics, right? The lawyers obviously contribute to that and need to understand it. But when it comes to the high math, trust me, I'm not doing it.
Yeah. No, usually you get experts and you have staff economists at both the FTC and the DOJ, but you need to be conversant. One course I haven't heard, probably, I can talk a little bit about my teaching in a minute, but is business associations and some of the corporate classes. Did you mention you took those, David, as well?
I did. I took corporations, and I can't remember. It's been a while. I can't remember either. Like Yvette, I can't remember everything as crisp as I thought I'd like. But I took corporations, and that's obviously very different. It's about corporate responsibility, shareholder responsibility, which I think is good to have a baseline on. The other thing I would say is I don't come from a financial background either. I wish I would have taken accounting type stuff. That's obviously not necessarily law related, but I do think that would have been helpful to me. But I really enjoyed. I do think the corporate, because when I obviously represent clients, some of that corporate stuff does come up. Like for example, in a merger, when they're facing antitrust scrutiny, whether it's a conduct investigation or a merger, corporate law comes up, and do we have to disclose this, right? So DOJ has issued a subpoena. Is that disclosable from a corporate perspective? And so at least I know a little bit about that interaction. But again, there are people who focus on that too.
How about M&A? We offer a course now on corporate transactions.
That would have been helpful. That was not offered at the time I was there. That would be very helpful too, because that's another thing that I do on a regular basis. I actually, am engaged in negotiating merger agreements, right? Because before they come to Yvette, we have to agree in the agreement, before the parties even announce the merger, right? What are the terms by which we're going to basically live by after we announce, and have to defend this before the antitrust authorities? And so are we going to have to, sell things or not? Who's going to drive the bus? And so a lot of those things come into that, is in my practice, at least, you're negotiating those merger agreements. And it would have been helpful to have a little bit more practical experience.
Yeah, a lot of that you learn on the job. I do want to switch to technology. Jim raised the question of technology, and a lot of students are interested in, not just at Syracuse, but I think throughout the country, in technology and intellectual property issues. We offer a curricular program in technology commercialization that I direct, and the Innovation Law Clinic. I do a course in advising the startups. So a lot of great interest in this. And of course, antitrust comes up. But we'll go back to you, David, because you do more of an M&A practice. Do you see a lot of technology issues come up in the M&A practice? Identifying intellectual property assets, assignments, those types of things?
Yeah, absolutely. I think that, and another thing I should have said too is that kind of antitrust enforcement evolves. You can kind of go from like the Reagan years, when there was a really kind of a hands-off approach to antitrust. You got more interventionist before that. Obviously, in today's world, the basic assumption is that Republicans will be somewhat more pro-business when it comes to enforcement versus Democrats. Obviously, we have Biden as a president, and people are predicting more aggressive antitrust enforcement. So I do think that kind of those things can really impact the practice. And again, it kind of goes back to the point we talked before. I mean, the antitrust laws are vague, and so I think there are some attempts to push the envelope, and technology is kind of the way that I think today there's been populist kind of sentiment that potentially antitrust enforcement has been too lax. And that you look at some of these big tech companies, and we all, we call them GAFA, Google, Amazon, Facebook, Apple, Microsoft to some degree, have gotten so big. There's been at least some criticism that, the antitrust laws have been inadequate in preventing that growth. And it really is the technology piece of it. They have too much data. They have too much IP, that they have network effects. And so they've basically built up, these businesses over time, and really kind of built a moat around technology and their practices. Obviously DOJ right now, and Yvette's group, or DOJ is suing Google, right? And part of it is, and FTC is suing Facebook, right? And so a lot of those evolve around what data they have, what innovation, that they are competing on and maybe squelching. And so, it's kind of a sign of the times, but I think technology really has become at the forefront, of antitrust enforcement.
Yeah, and so that I know you knew this was going to come up, but and so you can talk about it as you can appropriately. But what is your sense about technology, intellectual property, and antitrust, and the two companies whose names will not be mentioned, but you can
names will not be named. Well, I don't work on Google, so and even if I did, I couldn't say anything about an ongoing investigation, obviously. So no, I think what David said is exactly right. That I think technology does play a huge role in antitrust enforcement and analysis. I don't really have much more to say about it than that. And I think one of the questions is how flexible the antitrust laws are to deal with some of these technological innovation markets, and how whether there's a good fit there. And I think there are bills being introduced. I know that Amy Klobuchar has, Calera, which I think some of the bills that have been introduced and are being talked about in Congress today are addressed to those specific issues and trying to give the agencies some more tools in its arsenal to combat.
One dimension of this technology IP antitrust issue that I think we've been skirting around goes back to our original question about what is antitrust, and that is, one concern with technology is how it affects smaller companies. I think David used the B word in antitrust. So how much of that do you think figures into, and this interesting political alignment? I mean, whether Republicans don't like antitrust and Democrats do it. There is some sort of alignment or common interest when you're thinking about startups and competition and smaller companies along antitrust. Do you think that's accurate? I mean, how much in antitrust enforcement from the government side do you think is about protecting small businesses? I mean, that's, you go back to those debates over antitrust laws, 1890, Gilded Age, big companies. Sounds kind of familiar.
Yeah, no, it does. And, I mean, listen, I think that, what David said is somewhat true. I think that antitrust law has evolved over time, and you see, different political parties, whoever is sitting in the assistant attorney general for antitrust seat is going to make perhaps a different enforcement decision based upon their policies and outlook. But I do think that, right now, I think antitrust enforcement is pretty bipartisan. It's not just the Democrats on the Hill that are introducing bills. I think Senator Lee has some bills as well. So I do think that there is a push to kind of try to figure out how we do, undo some of these so-called trusts that have formed in their intervening years.
Yeah. And do you think there is a focus on, or talk, or at least in the background, a focus on small businesses, trying to make a better environment for startups or?
Well, we just brought the Visa Plaid case, which was in my shop, actually. I didn't manage that case, but that was in my shop. So I think that kind of answers the question that is, Plaid was a nascent competitor to Visa in the online debit industry. And we brought that case, and the parties abandoned the deal. But I think that shows that we are willing to bring those cases to protect nascent competitors.
Yeah. I don't know if you can talk about the FTC case against Facebook, but any thoughts about undoing the mergers? I mean, this is going to have this discussion earlier, but what is that? What are your thoughts about that?
I'll read in the press just the same as you. I'm not privy to the FTC's decision making, but I think it's an interesting.
Yeah, especially when you're thinking about it from the small business standpoint. I mean, that's one of the reasons why a lot of companies enter it. The startup is to be bought out, and now there's the possibility of undoing these mergers. It's interesting kind of twist. And Jim, as far as your practice, I mean, do you represent larger clients, right? Or do you sometimes work with startups or smaller companies in terms of your antitrust, either your view of what antitrust law is, or in terms of the kind of cases you take up?
Well, certainly both sides. When I'm on the defense side, it's almost always a substantial corporation. But when I'm doing the plaintiff side, back in the early aughts, I did a bunch of cases against Microsoft, monopolization cases, and those were often sort of failed operating system competitors or failed browser competitors. So yeah, big and small, but largely depending on which side of the V you're on. But I've actually got, I've got a monopolization case now down in District of New Jersey where it's just two large publicly traded companies going at each other, but they're fighting over big data, actually. And it seems to me that there's going to be, or there is already, a growing realization is just what power having access to data or rights to data, confers on any sort of, business. And it's not sort of what's traditionally thought of as market power, but it's a power that is really, really quite powerful, and something that can materially affect the state of a market, and who can have rights, who you're willing to license that to, and on what terms.
Okay, I have other questions as well, but I think this is the point where we're going to do a breakout. But I think, Kristen, we're going to do more of a Q&A at this point, or?
Yeah, I thought it might be nice, since we do have such a nice intimate group tonight, to allow all of the students to be able to ask questions of all of the panelists.
Sure.
Of course, if there's anything that, a panelist doesn't feel comfortable asking, please feel free that you don't have to. But since we have such a great panel that, will keep us all together and go around the room or raise your hand. But I know that Connor and I think Kelsey, a couple of students had chatted me in the chat box and said that they had questions. So Kelsey, I don't know if you want to get us started.
Yeah, I'd love to. This has been like the panel that I've been looking forward to the most because I have an interest in antitrust law. Don't be skeptical of me, David. I've
seem informed, Kelsey. You seem informed. So
I wrote my note on the Epic and Apple case right now. So I like to think I'm a little informed, but I don't know that much. So don't let me fool you. I have a lot of questions, but I'm not gonna monopolize the group here. But my first question would just be, because of how vague you guys have all said antitrust law is, would you say that it's frustrating at all for you to litigate or strategize mergers or anything like that? Would you get frustrated with how unpredictable it may be?
Yeah, I'll take a crack at that. And having, it's interesting, right? Because I think, as you know, Kelsey, I've spent time in the government too. So I've won and lost at the government. I've won and lost, for private companies. And what I would say is that, antitrust is vague. It's a vague law, and it's a much a common law based, right? So, go by court decisions, which sometimes are wrongly decided or rightly decided, depending on your perspective, right? But there's some value in having an independent, third party, judge, right? Article 3 judge actually review an antitrust case. In Europe, right? It's like, the European Commission's judge, jury, executioner, right? They don't go to trial. You can appeal it, but it takes like 10 years, and so it's really not an effective kind of appellate process. Here in the US, for better or for worse, Congress decided that if here's the laws, they are vague. We're going to let the courts figure it out. And we're not just going to let DOJ or FTC decide, right? They had to actually go to court to convince the judge, right, to block a merger or, to basically break up a company like Microsoft. And I think there's some value to that. What I would say, though, is that there's a real interesting dynamic, and I'm beginning to hear what Jim and Yvette have to say too, that at least in my practice, when I'm appearing before the agencies, it's a very different set of advocacy that you have there than you have with a judge, because DOJ and the FTC gets much more into economics. It's much more into very kind of complicated and complex arguments and issues, and kind of the cutting edge of what antitrust is and should be. But then you get sued by DOJ, FTC, you go to court, it's like, well, now you have to explain it to a judge that does not have that background, right? Because obviously the FTC, DOJ have economists, they have lawyers that are really on the cutting edge of antitrust. And so you have to be very sophisticated. You kind of have to go in there and make the arguments. But if they sue you, it's like a whole new ball game, right? It's like you're going to go in, and the things you argued before, you may not argue now, because now you look at the case law. You're saying, okay, well, now I'm going to piece together, and judges, right? There's a value in that process, but they're not experts, right? They're not antitrust lawyers, and so they do the best they can. And sometimes that's good, sometimes it's bad. But you really have to change tactics. And I think that's and for me, what I really liked about antitrust was I like the agency practice. I like that sophisticated part. I am a litigator in the sense that I do work on trials. I'm not a trial lawyer though. So there's a real science to, I think, taking that very complex stuff and convincing a judge either at the DOJ, FTC, or in private practice. And so this is one observation I have.
If I can speak to that, and really following right up on the end of David's answer there, is I don't find it frustrating. I think it's sort of the most creative work I do as a lawyer, is take these rather complicated issues of what's in the market, who's in the market, where are the borders of the market, and boil it down to an understandable, coherent argument within the law, as the law has been written, to a judge who's not an expert in it. And that's really interesting work to me. I don't find it frustrating. I think that's what I do best, and what I want to do is deal with complicated commercial issues, particularly antitrust issues, and be able to distill them down to a coherent argument that you can make to a judge who doesn't do it every day.
Yeah, I agree with Jim. I would say that too. It's when you said frustrating, I thought, well, it's challenging. It's what I like about what I do. It's a challenge to be able to exactly that, boil down very complex issues to a generalist judge. Although, you know, in the DC, in this District of Columbia, the judges they see antitrust cases a fair amount because we're here. So we generally a lot of times file here. But still, I mean, you're going to get a judge who doesn't, you know, isn't steeped in economics or antitrust law the way that what I do, I mean, I kind of wear two hats here. So on the one hand, you know, I'm investigating whether I think a merger or conduct violates the antitrust laws. And in that situation, I'm a fact gatherer, and parties, you know, David and Jim's clients are coming into me to try to convince me, and we can have that intellectual discussion about, you know, what their clients are doing is or is not anti-competitive. And, you know, if I disagree with them, then I'm going to recommend that we take an enforcement action. And that's where, you know, put on a different hat and go into court. So I kind of have a mix of both of those, which is nice.
Awesome. Thank you, guys. Those are really insightful answers. And so that's my first question. I know some other people have questions as well. So if anyone wants to just shout one out or raise your hand, whatever. Olivia?
Hi, thank you again. It's funny because what Kelsey said is same for me. David, don't judge me, but I definitely am interested in antitrust.
I'm impressed. That's great.
Before I came to Syracuse Law, I paralegals for 3.5 years at Hogan Lovells in DC and did their FTC and their HSR filings. So that's where I gained my interest. And that's also kind of where mine is a two-part question, my apologies. But my first one to David and Yvette, I'm curious if, what would you suggest as I'm a 2L. I'm curious on how to situate myself best. I know we spoke about classes and, you know, I already have my summer. But maybe in the beginning of my career, if I'm looking to have the opportunity at working in a government, like for the DOJ or FTC in regards to antitrust, what would you suggest is a great way to position yourself for that? If I know there's the federal honors program that you get in that way, but if that opportunity doesn't present itself, how would you suggest best positioning myself for future possibly?
And I do want to piggyback really quick. I'm so sorry. That hits another question that I had as well. And I just want to throw it out there that the antitrust class that several of you have mentioned is hardly ever offered. I've been looking for it for like 3 semesters now and it's never offered. So taking that also into account, I guess, what advice would you guys have for someone interested in getting more involved in antitrust law?
Yeah, you take that first? Yeah, since the government. Yeah, go ahead.
So yeah, no, we do have our honors program, which obviously you already mentioned. I would say if you know, be involved in the ABA antitrust section. You know, get involved in that, volunteer for that. You'll make a lot of contacts there. You know, read cases, read current cases. One thing that I'm constantly amazed at is when people come interview. We're in the middle of some lateral interviews right now, that they don't know what we do. You know, they don't take the time to actually research what the antitrust division did. Read our website. You know, read some of our recent cases. Kind of try to. I mean, you don't have to know everything that we do to get a job here, but I mean, just at least have done your homework, I would say. But you know, definitely get involved in the ABA antitrust section and the Young Lawyers division of the ABA. I think those are really great tools. You know, I like to reference the spring meeting, the antitrust section spring meeting, as the largest collection of nerd lawyers in the world, because it is. I mean, we're kind of nerdy. We like antitrust law, and that's okay. You know, so I don't know. David,
Yeah, I know those are great points, Yvette. I mean, I do think the ABA is a great source, to get involved, and they have like a young lawyer program too. I should know about it because I think that's what it's called, but you can join for free, and be able to tap into the resources and volunteer as Yvette said, on things like help write articles, to help do research, show an interest in antitrust. Again, you don't have to be an expert on day one. I also think too, one thing that someone had recommended to me that was really good is you can subscribe to the FTC and DOJ press releases. And so they'll literally send you an email every time they send out a competition related press release. And I still use that today. Like I love that because I get to see what they're doing. You can read the press releases are pretty short, a couple pages. And maybe you don't have time to read the entire case or the complaint, but you get a lot out of the press releases. And so you can see what's going on and just kind of attune yourself to kind of what's going on in antitrust, I think is the way to do it. I think from a law firm perspective, I think when we look at candidates, and obviously there's lateral candidates that come from the government or come from from other law firms. Law school candidates, I would say that you do get people that have a real interest and they've taken classes, but to me that's not if you came to me and said, I really am interested in antitrust and I want to work at Skadden, the fact you hadn't taken antitrust would have no bearing on me. I mean, I think we'd want to explore why you think you want to do antitrust, but also recognize you kind of know what you know, but you don't know what you don't know, kind of. And so I think from my perspective, there's a lot of other things that go into an attractive candidate, for antitrust. I also think too, do you actually have done things outside of law school? Have you done like clinical practice? Have you, what kind of summer jobs have you had? What kind of work, have you written articles? Have you, obviously Kelsey, that's great that you did your note on it. I'm going to read it too, because we're actually, Skadden's involved in that case. So I'll say that, but, one thing I get asked a lot too, and I'll ask a question, answer it. A lot of people ask, are you better off doing antitrust in private practice first, or going to the government first? And my answer is that, you can start either place. I think you'll get great training. Obviously I see the product. I didn't get trained at DOJ, but I certainly see the product of the people that are trained there. I see the quality. I mean, we try and steal, the people that, that Yvette, trains, and then we try and get them to come to private practice because they are so well trained. And the same thing goes, I think, Yvette, you can comment on this if you disagree, but we get great training at law firms and they go work for the government. And so I think you have the ability to decide later if you want to do, what I would say is I highly recommend doing both though, because I think it made me a better lawyer to see both the prosecution side and the defense side. But I don't think you have to decide on day one out of law school, I have to work at DOJ, FTC, or I have to work at a firm. I think you can do either and then decide later to make a move.
Yeah, I would actually second what David just said about having been in private practice has, I think, really made me a better lawyer and made me a better prosecutor, actually, because I kind of know how they tick.
Yep, absolutely. And I think it makes me a better defender, having understand how, what matters and seeing, because you get to see so much. So when you're in the government, you see so many cases, right? Yvette probably sees 10 times the amount of cases that I work on because she's, seeing stuff come through. And I think there's some real value in that.
My second question is for Jim. I lived in DC, like I mentioned before, but if I'm curious in going elsewhere, I'd love to know how it is antitrust outside of the realm of DC. I know it's a pretty DC focus, but my understanding is that you are in Texas right now. So does that shape things differently? Obviously, if I were to do what I did as a paralegal, I couldn't have done it unless I was in DC, HSRs, but just curious on that realm area wise.
So look, all of the agency work, is focused in DC, but the private enforcement, lawsuits are brought around the country. And you really don't have to be in any particular place in order to do that. You really have to look and say, okay, who are the law firms that do the good work? And they're spread around. I mean, my office happens to be in Houston, but we have offices in New York and LA and Seattle as well. The really top quality antitrust litigators are all around the country. And they tend to be in the big cities, probably the 10 biggest cities in the country. But, there's also, I don't know if Seattle's in the top 10 big cities anymore, but, or maybe it is now and wasn't before, but, because there was so much antitrust litigation involving Microsoft. There was a whole cadre of good antitrust lawyers in Seattle. There's a whole lot of, antitrust work now that takes place in the Bay Area and San Francisco. And there's a lot of antitrust lawyers out there. So if you want to be in private practice, you are not by any means limited to DC, but there are sort of, some hot spots. I'm in Texas, which is not an antitrust hotspot. I have never had an antitrust case in Texas. I spend a lot of time on airplanes, or at least I used to.
And if I just might add, the thing to look for is where the business centers are. Dallas has a lot of corporate headquarters. American Airlines sees a lot of antitrust litigation, or Houston, a lot of headquarters are moving into Houston, but oil and gas and shipping, these are big business centers. Chicago, Seattle for Microsoft, Silicon Valley for tech, and then obviously New York and New York City, and then Washington, D.C., just because of the administrative practice that goes on there. So that's what I would look for, is where the business and the legal work is. And that can be lots of places in the U.S. One question I didn't mean to interrupt, but very quickly, because I think it ties in. One question I was going to ask you, because we have a lot of students who are interested in international practice, and antitrust does have an international dimension. We talked about the European Commission. Do you have some comments on that, or you can start with Jim? Do you have international type practice as well?
So I do, and I've got a case now where my client is not only trying to talk to the FTC, but also to TG Comp. But perhaps most interestingly, to sort of as anecdotally, I've got a case that I filed in 2005 against a group of Chinese, mainland Chinese People's Republic companies. It's called the Vitamin C Antitrust Litigation. It's gone all the way up to, there was a 2018 decision from the US Supreme Court that Justice Ginsburg wrote that where the issue was, it was an antitrust case, cartel case against the Chinese manufacturers. That the issue before that got to the Supreme Court was, though, when a foreign government, in that case, the People's Republic of China, comes into a United States court and says, this is what my law is. Because there was an issue of whether or not the Chinese government had compelled and forced these companies to violate US antitrust law. Question before the Supreme Court was, how much deference must a US court give to a foreign government that comes in and says, my law required this and required a violation of your law? And, it's a kind of a touchy question, it turns out, because, you don't want US courts telling, foreign governments that, you're in here lying about what happens in your own country, but you also want the US, government, when it turns up in some foreign court, to, be given, significant deference as well. So there's a, like I say, a Justice Ginsburg opinion from 2018 that, talks about what you need to consider, what factors a US court and judge must look at when trying to determine what a foreign company or foreign country's laws are, and when determining whether they're in conflict with US laws. So.
Yvette, do you find a lot of international investigations?
I used to. So before I came to my current section, I was in telecommunications section, and I did a fair number of international telecom deals or joint ventures early in my career. So I interacted a lot with the UK, CMA. I still do. We have mergers that are have international filings. So we coordinate with our counterparts around the world. In the UK, the EU, Brazil, Mexico. And so that occurs a fair amount, yeah.
David, does your transactional work also take you to international?
Yeah, absolutely. If you look at Skadden's antitrust practice, we have just as many antitrust lawyers outside the U.S. as we do in. Just tells you that corporations, whether doing transactions or facing potential antitrust issues, it's global, and as Yvette said, we oftentimes, we have a merger, for example, you may have to file in 10 countries in addition to the United States, and any one of them can block your deal. And they will coordinate closely, if it's a global market, they'll coordinate closely with DOJ. So you have to, consider that kind of collaboration, that coordination. And so, yeah, absolutely, you have to do that. And I think for an American lawyer, obviously, you're relying on the local experts. So we have, lawyers in Europe, Europeans that are, primarily appearing and handling the European aspects of antitrust, and same for other portions of the world. But as oftentimes the U.S. lawyers kind of decide the strategy and are the primary contacts with the client, and so we'll have to really understand the intricacies of what's going on in Europe, what's going on in Asia. China is a huge player in the merger enforcement world these days, and so you really have to have local expertise, but also kind of that global coordination. And I find that'd be fun. I mean, I think that really does add another complexity to antitrust. If you're someone who really enjoys, that complexity as well, can be very rewarding as well.
Great, thanks. I didn't mean to interrupt you, Olivia. Did you have a follow-up, or Kelsey?
Yeah, I'm sorry, I didn't hear you.
Kelsey, did you have a follow-up, or?
I have more questions, but if someone else wants to ask one before I go again, that would be fine.
Okay, I'll jump in, Kelsey.
All right, Connor, I'll let you go.
I do have an econ background, but I am not as well versed as Kelsey in antitrust. So I was wondering, how does econ come up in antitrust?
Well,
Yeah,
I can jump in and say, so we have 2 sections of PhD economists. And from the time that I open an investigation into a merger or conduct investigation, an economist is assigned. And we work hand in glove with those economists to come up with the theories. The theories to do empirical modeling and try to calculate whether this conduct might result in harm. So it's a very, we work with these economists every day from the get-go. So it helps to be conversant, to be able to, and sometimes to be able to translate econ speak into English for the court or for others that you have to convince.
And I would say that, the way it comes up in my practice is that the first question that always gets asked is, what market are we looking at here? Are we looking at the market for PC operating systems? Are we looking at the market for automobile tires, whatever it is? And that's actually an economic analysis, not a legal analysis. You need an economist to sort of tell you what the metes and bounds are, the market are. And then once you define the market, then you sort of need economists to help you say whether, does any participant in this market actually have any market power? Is anybody big enough? Has anybody got some, special, aspect of their offering that permits them to raise prices above the competitive level? And there's all those questions, which are sort of fundamental to an antitrust lawsuit, are largely the province of economists.
Yeah, maybe give a quick example. I think that's right. I mean, antitrust is about defining markets, defining concentration levels, or assessing concentration levels. Looking at entry, whether that might offset some of the power that exists in the marketplace, but also what's the effect? Antitrust is really focused on, obviously among other things, but really price is the one indicator as to whether or not, behavior or a merger is harmful. And so the economists can do many sophisticated things to figure that out. And a good example of that is not too long ago, the FTC challenged the Staples Office Depot merger. And so the question was, okay, we have these 2 big, brick and mortar providers of office supplies, and they're superstore office supply sellers. But if you want a pencil, if you want an eraser, a pen, you can go on Amazon. You could go to Walmart, right? You could go to the local drugstore maybe. And so the question was, is there something special about that competition between the big box superstores, such that if you lost that competition, would the price of those things go up? And so the key question was, hey, how do you figure that out? And so the economists, looked at, and they could actually look, kind of city by city to say, okay, well, when we see Staples and Office Depot together, prices are lower. If it's just one of them by themselves, prices are higher, regardless of Walmart's there, regardless of Amazon. So you could tell, okay, if you take away that competition, the theory was prices would go up. Now, obviously, an economist would be like, Dave, that's like the stupid explanation, but that's it. That's really, and so, what's interesting though is the economists did that tough work. And then, litigators, like Jim, then had to explain that to the judge as to why that meant, that the deal was was anti-competitive, should be blocked. And so, so the economists are critical to this piece of it, and they play a huge part in the agency practice. As Yvette said, the FTC and DOJ have tons of economists running around that are involved in every case, but also in courts. I mean, courts, really do look to economists as being another tool for them to figure out whether a merger or conduct is unlawful.
Going off of that real quick, so you guys will get these economic analyses from your economists, but then once you have that, to what extent do you guys really interact with that? Do you take it and run with it, and then you do more of you take a more legal approach? Do you really kind of go in depth into the economics? Like to what extent do you guys specifically work with econ? Because for me personally, I think it's super interesting. I took several econ courses in undergrad, and so if you're interested in really marrying the law and economics, are you able to do that? Are you able to get more involved in the economic approach of these cases, or do you really just kind of let the economists do it and then you take their work product and run with that?
I think it's more of an integrated work product. So, I mean, the economist at DOJ will write, for instance, called an issues in memo to our front office, which kind of outlines what they think the economic issues are in the case, and like if it's a product market question, and then the empirical studies that they are going to or proposing to do to answer some of those questions. But they work with us they sit in our interviews of parties and third parties. They help us to craft data requests in our subpoenas to try to get some of the data. I think David alluded to Office Depot Staples case. I think they used a lot of scanner data to come up with to show the price effect of when there were those two versus when there was only one in the market. And so we really do work hand in glove with them. And what we come up with at the end of the day is a recommendation to our front office, to the Assistant Attorney General, whether we think we should sue to block a merger, or whether we think we should take some other conditions and divestitures, or whether we just think we should close the investigation. And EAG is going to sign on to that. Our EAG is our economic analysis group. So they will sign on to that. It's very rare that they're going to write a separate dissenting memo. That does happen occasionally, but we try to weave their analysis into our recommendation. Does that answer your question?
Yeah, I think I agree with everything Yvette said. I think the lawyers though are the ones that really, no offense to the economists, but are the ones that drive the bus. Yeah, they're not on.
They're the ones that write it.
We won't tell them. Yeah, I mean, like for example, the Assistant Attorney General, the Chairman of the Federal Trade Commission. Guess what? They're lawyers, right? They make the decisions, not the economists, and so they really are an integrated team. I don't mean to say that pejoratively. But in the end, I think there are legal decisions that have to be made, right? Is this a case that's worthy of prosecution by DOJ? Is this a case that, the lawyers think the company can defend and win, And so the economists are like a really important tool. But I think, as I think about it, because again, I don't have a really strong economics background. I just kind of learned along the way. It's not like you have to be so immersed in the economics that you could do it yourself, right? You have to basically be immersed enough so that what's going to matter and make a difference. Because the economists could go work and economists charge a lot of money. We laugh and say, law firms, cost X, basically e-discovery vendors are 2X, and then, the economists like 5X. I mean, I'm going to tell you, there are economists out there that charge like $3,000 an hour. And I'm not kidding. I mean, that is, those guys make tons of money. And the reality is that as a lawyer, you really have to understand enough to know what's going to matter, to the lawyers that are making the decisions at DOJ, FTC, to the, guess what, the lawyers who are judges, right? They're not economists, right? They're judges. And so the lawyer really has to be able to understand it, to use that tool, to integrate it the way Yvette said, but really make the decision as to what to use and not to use. Because you can't just run in there and say, oh, I'm going to turn it over to my economist. I mean, when's the last time Yvette, somebody came in and said, oh, I'm going to have the economist run the meeting? And we'd be like, oh my God, don't let that happen.
Well, I don't want to start a street fight. I'm an acting economist and a lawyer. So, but I think I've been expert witnesses, not at the 3,000 level, but somewhat close. But so I agree with what you say, but this does raise an interesting question about what does guide the law, and this kind of goes back to how we started this discussion about what is antitrust. And so you're right. I mean, the lawyers have to decide, but the judges have to ultimately decide. But they're, hardcore antitrust folks are guided by the economics now, right? I mean, it's not based upon some broad notion of the public interest or. It's about, are consumers better off? Is it about? So, I mean, I guess maybe this is a question for Yvette. I mean, you make a judgment about when something is anti-competitive. Well, what does that mean? Does that mean prices go up? Does that mean, because there are situations where prices go down, and that's been the brunt of sort of the charges against Amazon.
Yeah.
That, so what do you think anti-competitive means from a legal standpoint, from an economic standpoint, from a political standpoint, from a common sense standpoint?
I mean, yeah, we're looking to see whether, prices will increase or output will decrease, or quality will decrease. I mean, that's what we're looking for. But I think the decision about whether we go forward with an enforcement action or not doesn't just depend on whether we think a deal is anti-competitive.
Right.
I mean, you mentioned before, we have as the government, we have the burden of proof in court, and there are a lot of litigation risks that I think need to be weighed and are weighed in that analysis. I don't make that decision. I make a recommendation. I have to outline, everything. So I outline, the economics. This is what we have. This is what the facts show. This is what our economic analysis shows. Here are the litigation risks. And then someone at a higher pay grade than me makes the decision about whether we want to expend, we, the government, want to expend our limited resources pursuing the matter.
Yeah.
And that's a policy decision that.
A couple of years ago, we heard the phrase hipster antitrust. You think that's just a passing, passing tweet to bring that back up?
I don't really even know what that means.
Yeah, I think, I don't know what that meant either. So I guess, there is an interesting question with Amazon about, prices going down and I guess maybe output going up, but at the same time, Amazon now is a potential of dominating all of these markets. I don't want to get into the weeds with monopoly power and whether Amazon
over the long term, whether consumers are better off with that. I mean, that's this $64 million question.
Yeah. Well, it's also too, it's free products too, right? I mean, there's a lot of, that goes back to the technology kind of innovation part. How do you measure effects when, big tech companies are giving these away for free, and so, are consumers better or worse off when they're getting something that they don't have to pay for? Is from a quality perspective and innovation perspective, there's some really difficult questions there that I think, the law and economics are still struggling to answer, and
Professor Ghosh, is anything really ever free? I mean, you're an economist, so.
No, of course not. Yeah, I mean, I'm not sure what you mean just giving away. What are the free things you mean? I mean, you're always.
Well, it's the Amazon Prime, I think, is what you're talking about.
Or the Google type things.
Yeah, or a lot of the internet services are not, they're advertising, right? I mean, that's what I mean.
So that's what
don't kid yourself. There's not money changing hands, but if you're worried about impact on consumers, right, you can't find that price increase.
Right. No, exactly. Though, I mean, this is where you get all this interesting question about whether you're paying in data, right? This is where some of the, at least the state claims against Google in the advertising area is whether, you are paying, but you're paying in privacy. And so how does that figure into this? I mean, if I were to just answer kind of question, but I also want to take it as Hilda. Yeah, I see Hilda's has her hand up. Hilda? Hilda's iPhone.
Sorry, can you hear me? Hilda's iPhone. Hi, and I jumped in this late, so I may have missed this, but I'm interested in IP, but I'm very fascinated with antitrust. And I'm just curious if anyone on the panel has worked within like IP and antitrust. Kind of, have they seen like an intersection between the two? Because it does appear like they have different objectives, but I'm just curious to hear how the two work together, if anyone's had an experience working with IP and antitrust.
We did talk about this earlier, and yeah, it happens all the time actually. And a common kind of posture of a lawsuit will be that somebody sues the other side for stealing my trade secrets, and get a counterclaim back saying, yeah, but you're monopolizing or exercising undue market power through use of these trade secrets. And how a patent is nothing but a legally sponsored monopoly for a period of time, right? There's competition laws all around IP law, frankly. So yes, it's a intersection that is common and of significant importance these days.
Yeah, and it's a good question, Hilda, and I think it does come up, in different facets in antitrust. I mean, IP can be seen as an asset. So if you're actually doing a merger, there might be a question as to whether you're accumulating, maybe a patent thicket, or you are, accumulating market power through IP. The DOJ and the FTC have looked at IP and antitrust intersections for, I guess, decades, right, Yvette? I mean, it's an interesting question. It also comes up too, one thing when I was at the FTC, that is kind of an ongoing issue, is what we call reverse payment cases, where a branded manufacturer of a drug has, as Jim said, kind of a natural monopoly, right? You actually you discover a new drug, that's great. You get to have a monopoly for a certain period of time. But inevitably, right, under our patents, right, that those expire. And so a bunch of generics are going to team up, right, quickly to kind of come in and take over that monopoly and sell drugs, obviously for much cheaper. And consumers get a huge benefit from that. Like literally, a drug, can have billions of dollars of sales. And if a generic comes in, the price can go down by, 80%, 90% over time. And so there were cases where the branded manufacturers, I'll say allegedly, right, would enter into agreements with the generics and say, hey, you know what, you're going to enter. And the way the IP worked, there, the Hatch-Waxman, which I will not get into. There's a way for the brand to do an agreement with the generic to basically, lock up the generic entry for a period of time. And then allegedly the two of them would split that monopoly profit. So the brand would say, if I do an agreement with you, I can prevent entry from coming in where I lose 90% of my profits. Hey, why don't you agree to enter later and we can enjoy the profits together? I'm going to pay you, X amount of millions of dollars, right? And so this was happening for years and years and years. And finally, the Federal Trade Commission intervened, trying to change the law against, convincing judges. They finally, got and it's a mixed bag, but got a Supreme Court decision that said, yeah, you know what, that's not per se lawful when you do that kind of agreement. Actually, it can be anti-competitive. And that's, one example of where IP and antitrust intersected.
And there was a big Fifth Circuit decision this week, all the impacts, which maybe expanded Actavis a little bit. Supreme Court.
Yep.
It's interesting.
Sorry.
Yeah, go ahead, Olivia.
Sorry.
I'm sorry to interrupt, Olivia. Just Yvette, what's your thought about this? As Hilda knows, we've talked about the DOJ, FTC antitrust guidelines from 1995 regarding licensing of IP. How have those affected maybe what you do or what you think goes on in the department?
Yeah, I mean, obviously they're kind of old, 1995.
Yeah. Well, there were updates a few years ago, but they're old. But yeah.
Yeah, I mean, it is something that arises a lot in what we do. A lot of the mergers are going to involve, as David was saying, they're going to be an amalgamation of a bunch of patents, and the question is, whether they can use them to block entry and foreclose entry. So those are issues that we address.
Yeah, those guidelines were also pretty important. They actually made headline news in the Bay Area, San Francisco Bay Area, when I was practicing up there. That's unusual for that to make the headlines, but it does show how antitrust and IP, actually do have common goals. And I mean, they're important in recognizing things like innovation markets and things that we take for granted now. Sorry, Olivia, I didn't mean to interrupt, but do you want to follow up? Or?
Yeah, I'm sorry. Clearly, I'm like Kelsey, just way too excited with questions. But I know this is a question that also Hilda and I have discussed. I know we touched on it briefly a little bit earlier, but I'm really interested, and I would love to hear each of your insight on this kind of what seems to be new, and I'm a baby antitrust person, so at least it seems like it's upcoming, but this concept of privacy and data exchange, especially when it comes to mergers and acquisitions, because there's so much information right now. I'm not going to talk about what I did for my note because it was painful, but one of the things I wanted to kind of, in my research, we talked about how like Fitbit bought out Ancestry, for instance, not Fitbit, but Ancestry, the genealogy was, I think, bought by Blackstone, or maybe it was 23andMe. I'm sorry, again, my note was questionable, but just that cost of data and how much there is. So I know that it seems like regulatory, they're still kind of struggling, but what does the future, I guess, of antitrust look like if we're starting to talk about that and like data exchange? I don't know if that's always been a thing. It's just like coming to me now, but I'm curious to see, what do you guys think the future will look like in that respect, possibly what we would be practicing?
I'm happy to take a crack. When I was at the Federal Trade Commission, we worked on the Google DoubleClick, matter, and that involved, kind of the intersection between privacy and antitrust. And what's interesting, right, is unlike DOJ, the Federal Trade Commission actually has a consumer protection mandate in addition to an antitrust mandate. And there was this push that we kind of see today where maybe you should merge them together, and maybe antitrust should do more than just protect competition. Maybe it should, protect privacy, protect jobs. I mean, that's like today, this is like constant debate today about, should the laws, as Yvette said, should the antitrust laws be changed to go beyond just protecting competition? But the reality is today, they really do protect competition. So you can't go into a court, and this is important, right, to say, hey, under the Sherman Act or the Clayton Act, we think that they're, basically, violating those because they're doing something to privacy. Because there's different laws, where there's consumer protection laws that go after companies for not protecting your data. The FTC does that. There's other agencies that do that. But there is an element to competition and privacy, and it's really a non-price. If you think about the bad things that happen to people, right? One is you can pay more for your goods, right? Or there'll be less of your goods and the price goes up, or maybe the quality goes down. People, I think and this is debatable, but under the current laws, privacy really is seen as a quality, competition. And so one question in Google DoubleClick, this is all very public, was, hey, if Google buys DoubleClick, will they value privacy less? And so people who are getting these free services, obviously in exchange, guess what? Google's selling your data, right? And so they're monetizing your data, and there could be some potential privacy. Facebook's another one too, right? Another element of privacy there. One big thing too that we see is that there's kind of a competition going on between Facebook, Google, Apple, to basically try and cater to consumers to protect your privacy, right? And so antitrust, the people are trying to take antitrust because it is vague and make it be a privacy protection thing. And it's really hard to do because the law doesn't really accept that, except for maybe as a quality. And so, for example, if you could allege that, hey, Google, I'm just making this up, but Google and Apple are going to merge, right? That would be, that'd be big news, right? And that there was concerns that somehow there'd be less privacy if Google took over, because they maybe arguably they value privacy less or think about privacy differently. That could be an element of competition, that you'd worry that potentially they're competing on privacy today, that if tomorrow they merge, they wouldn't compete on privacy protection anymore. But that is like that's a huge topic that's being debated today as to whether or not antitrust should be expanded to cover privacy.
Yeah, I mean, if I could just add to that, I mean, that's absolutely right that antitrust is different from consumer protection. In fact, I was going to chime in like an hour ago when we started this conversation about how antitrust protects competition. That's right. You need to distinguish that from unfair competition, which is a whole other body of law comes up under the Lanham Act and FTCA and state law. But you know, the whole role of information and data in antitrust is a big one, and whether access to data gives some people, some companies, competitive advantages. The one issue that's come up in Amazon, as it's basically in Amazon, it's a platform, but also competing with other companies. It's selling its own brands, its own kind of versions of products, but it has all of its data about who buys what. And that certainly gives it, I mean, imagine if you had all this information about your competitor, but you're also competing with them. It raises some questions about whether that should be a basis for an antitrust claim. That is different from consumer protection and protecting privacy. We zoomed out, and I find this very exciting, but I don't want to, you know, burn the midnight oil, since I'm sure everybody's been on Zoom many hours today. I know I have a little bit. Kristen, did you want to go in another direction, or?
I think unless we have one last question from a student, or if you have a last final question that we could ask the panelists, and then we could have, you know, Connor's reflections and say goodnight for the evening.
Okay. I'm questioned out. I've enjoyed this, but I would like to give the panelists to maybe give one or two last pieces of advice. You know, Jim, we haven't heard from you in a while. Do you have any last piece of advice to give our students?
Well, I'm both surprised that there's people in law school who know they really want to do antitrust. I kind of got to that point sort of when I was looking for a job, but wasn't just an area of free-floating interest. But I don't know, it's been a really good career for me. So if you like it, you know, try to get a job in it and see if you like actually doing it, you know, round the clock, you know, for a living. But it's been very rewarding for me, and I've really liked it. So
that
I would just echo that. I mean, I love what I do. I find it intellectually challenging and personally rewarding to be able to stand up and say I represent the United States of America. That never really gets old. I am excited to hear people that are excited to want to do antitrust law. And even those who don't know if that's what they want to do, I would encourage you to dip your toe in the water. It's fun.
Wonderful. And then David?
Yeah, I would say that you know, I kind of fell into it, but I love it, and I'm so glad that I got to do it. And I think it's funny because whenever, you know, I would talk about antitrust back when I was a young lawyer, people say, "Oh, it's a very narrow practice," and I think that's really short-sighted. I think it is obviously kind of a niche practice if you think about all the other types of law that you could practice at a firm or in the government. But what I really like about it is basically has a little bit for everybody depending on your interest. If you want to be a litigator or you don't want to be a litigator, you can do antitrust. If you want to do criminal or civil, you don't have to decide. You can do antitrust, right? And I think if you want to do prosecution or defense, you know, you can do antitrust. And so I just think there's so many ways of catering to your specific interest within the antitrust practice, so that it is pretty broad. I think there's just lots of opportunities, and I do think there's a really good mix of. And Yvette kind of said, I mean, you know, you can definitely get your geekiness in there, but also the practical side. You can't just be a geek, right? You also have to be, you know, someone that's well versed and understands how to translate complex law for laymen, right? That don't understand it. And so I find that to be a lot of fun and a challenge as well.
Great. Well, before I turn it over to Connor, I just personally want to thank three of you for, you know, sharing your time and your insights, and also thanks on behalf of College of Law. So it's been a wonderful time. So thank you.
thank you very much.
Yep. Thanks, everybody.
And I hope people keep in touch, and very good. Hilda, did you have a question or comment?
No, I was just clapping.
Oh,
the
okay,
emoji.
sorry. It looked a lot like your raised hand icon. Sorry. So thank you again, and thank you, Kristen. And Connor, I guess I turn it over to you now.
Yeah, thank you, Professor. Like Professor said, thank you to our panelists for taking the time tonight to join us. And Professor Ghosh, thank you for moderating. I thought it was fantastic to hear about all your experiences and actually learn something about antitrust. It was nice that Zoom gave us the capability to have you all here tonight. And that's been one bright side of this virtual realm the pandemic has provided us. We thank you for coming back and discussing with us students, answering our questions. So really, thank you again. All right, everyone, have a great night.
Hi, thanks everybody.
Everyone,
Take
Take care and go Orange.
Good night. Good night. Yep, go
Thank you
Orange.
all.
bye.
Bye.